Hello landlords, it's Ernie, I'm back. And today we're talking all about repairs. What's a reasonable time frame for a landlord to complete a repair? Let's get started. I hope you're enjoying every new video we produce. We put one out every single week, and we do it based on the kinds of things that you're posting below in the comment section. Tell me what you think about this week's video. Tell me what you think about things that I should share with you guys in the future. Let me know your thoughts and opinions about what's going on in your neck of the woods. If you enjoy what you see, give us a like. And if you haven't subscribed yet, consider subscribing. What is reasonable when it comes to repairs? To be honest, this is a determination that is ultimately made by the court. Was it reasonable for you to wait as long as you did before you completed the repair in question? But not all of these issues ever make it to court. In fact, most never do. And so it's a determination that is made between the landlord and the tenant. So if you have a tenant that's requesting or demanding that a repair be completed, when do you know whether or not you've crossed the line when it comes to being reasonable? Let's consider a few factors. First, is the repair in question an actual emergency? You hear that term a lot. Oh, I've got an emergency. You need to get here fast. My ... whatever is no longer working. Well, again, different situations are going to call for different things. Your lease might, for example, say something to the effect of, your AC going out isn't an actual emergency. Is the dryer going out an emergency? Is the garbage disposal going out an emergency? Is the electricity going out an emergency? Again, some of these things are things that you can deal with. Some of these things have nothing to do with you. But when it comes down to the determination of an emergency, it has everything to do with what the expectation is in the rental. I don't know, is the dryer like one of these fundamental things that is part of your lease? Probably not. And so it's probably not an emergency when the dryer stops functioning. Is it a hassle? Is it a pain? Sure. But is it even a requirement in your lease? Sometimes leases state that the appliances are the sole responsibility of the tenant. But if your lease doesn't say something like that, or if the tenant doesn't own the equipment in question and has full responsibility for it, you have some duty to your tenant to get things done. The tenant is paying a certain amount of rent based on the items that were in the unit at the time that the lease was signed. If you are no longer delivering, as in this case, a working dryer, then you may not be giving the full value of the lease to your tenant. But what is reasonable? Are you required to get it repaired within 24 hours? No, probably not. In most cases, the courts are going to consider precisely what's going on and how great a need there is. Might it be reasonable for a repair to take, say, 2 weeks? It might, but if you can't at least demonstrate some diligence on your part to respond within a reasonable time, the court could take into consideration the fact that it took you 10 days to first get out there. The court will also take into consideration the complexity of the repair itself. If all you needed was, I don't know, a new cord for the dryer, or perhaps a breaker was tripped and all you needed to go do is flick the switch on the breaker box. But if you didn't respond within a reasonable amount of time and your tenant was left without a particular resource, the court might find that your actions were unreasonable and may end up compensating the tenant to a certain degree in a case filed against you. So I've heard some landlords say, well, I treat all of my tenants the way I would treat my own family. And that's a pretty high standard, I guess, depending on your family. But it's not necessarily a required legal standard. Again, you're shooting for reasonableness. If your tenant informs you that a repair is needed and you can reasonably attend to it within the next 24 hours, then you should. If it is unreasonable for you to do it, you should do it at a time that does make some sense. You don't have to rush over at the first call, and you certainly don't have to do it, particularly if the matter is not an emergency. But do consider whether or not your response to your tenant is reasonable. And it has nothing to do with whether they offended you the last time you spoke to them or whether they're not very nice. The court doesn't take those kinds of things into consideration. The matter comes down to the blanket request itself being reasonable. If it is, and you act unreasonably, the court probably isn't going to see things in your favor. Next, is the repair in question something you can even fix, or does it require some other expert? I myself am not very handy, and so it wouldn't make sense for me to go even try to look at some piece of equipment that I had no idea how to repair. So if you're in a similar situation, maybe it makes less sense for you to plan a visit 2 or 3 days after the request, and then you make a call to have someone else come 2 or 3 days later. That delay may be seen as unreasonable. If you know for sure that you want to go and see what's wrong, you should act with diligence. Be there as quickly as you can, and then have someone out there, again, as quickly as is reasonably possible. If it's something that you can fix, then it makes things a lot easier for you to get things done in a shorter amount of time. Now, it may be that for most things you're pretty good at fixing it, but you come across something that turns out to be a bigger project than you first anticipated. That's okay. Again, if you act with reasonable diligence to get a repair completed, the court will look favorably on that. Is the request from your tenant in writing? Not every request is made in accordance with the written terms of a residential lease. If your tenant has sent you a request but has failed to do it in writing, sure, you could hold that against them, but you're neglecting perhaps a customer service element of the landlording role. The fact that you decide, well, because my tenant didn't request this in writing, I don't have to do it, may not, again, be looked on favorably. It may not appear reasonable to a court, especially if it was a legitimate emergency, right? So after a storm of some kind, a flooding event, don't rely on the request being in writing before you respond to it. If there is a legitimate emergency, you should respond promptly. Is the rent current? Many leases provide a clause in the lease that requires that rent be current before any request for repair is responded to by the landlord. If you have a tenant who is requesting a non-emergency repair and their rent isn't properly paid, you've got a choice. You can go forward and take care of the issue, particularly if it's something will just get worse over time. But you should also exercise your rights in terms of enforcing the lease. If your tenant has failed to pay rent on time and are demanding a repair, even if you show up, you should probably show up with a notice to vacate. Now, you may hear the excuse, well, I'm not going to pay rent until you complete this repair. That's not what the law allows. There are provisions in Chapter 92 of the Texas Property Code that allow a tenant to apply, part of a repair, the cost of a repair, to rent, but they would have had to follow a very strict set of guidelines and requirements under Chapter 92 of the Texas Property Code. If they haven't done that, then they're not even eligible for that kind of remedy. Again, if your tenant has failed to fully pay rent, you have the right to demand that rent be paid. You may decide that you want to complete the repair, but I would suggest also simultaneously handing in a notice to vacate to the tenant and simply enforcing your right to collect the rent. If you do this as you've completed a repair, you may have less of a likelihood of tension, and the tenant may in fact immediately pay. That's a good scenario. But if after the repair you still receive some hesitancy because the tenant is dissatisfied with the repair, you may want to go ahead and proceed with an eviction. Does it have to shine? I hear this from time to time, that tenants demand A+ work. You have to get the best plumber in town. You have to use, the best equipment. They will accept nothing less than A quality work and craftsmanship. Well, that's, again, not the definition of reasonable. Reasonable, doesn't demand perfect. It also doesn't demand the very best. But if you sold your lease on the promise that all of your repairs would be done in a certain quality or of a certain distinction, then maybe your tenant has an argument. Otherwise, generally speaking, as long as you've made a diligent effort to complete the repair, you've done your job. Can the tenant sue you? Well, you've heard me talk more than once on this video about the court's opinion or the court's perception of the reasonableness of your actions. So yes, a tenant can sue you. They can do it in the justice court. The same court you use to enforce evictions can be used by the tenant with a repair and remedy lawsuit. In this lawsuit, the tenant can demand that you complete a repair, particularly if they have complied with Chapter 92. This particular section is 92.056 and 92.0563, in which a tenant is given certain rights under Texas law to demand that you complete a repair or that you compensate them for a repair that they have completed. If your tenant has sued you for a repair and remedy case, you want to make sure that you have acted with diligence. If these are facts that need to be presented to the court, you want to make sure that you've done everything on your end that puts you in a winning position. Well, you've made it to the very end. I appreciate you sticking around. If you enjoyed what you saw today, give us a like. If you are interested in being a subscriber, there's a picture of me right here. If you're interested in watching more, YouTube seems to think this is a pretty good video for you to watch. Comment below if you have any questions or anything to add. We're happy to hear it. Until next time, landlords, happy leasing.